Hello, everyone, and welcome to this webinar exploring 5 key topics under the EU AI Act, Part 2. My name is Ooms Wannes. I'm a researcher at KU Leuven Center for IT and IP Law, also called CiTiP, and in that capacity, I also work for the Flemish Knowledge Center Data and Society. This is our second webinar that we're hosting under this title. If you were present for the first one, welcome back. You will already be familiar with our format and with the practicalities. If you didn't attend our first webinar, then you're of course also very welcome. And you will have noticed by now that your microphone is muted and that your camera is turned off. This is of course for practical reasons, given your very numerous attendance here today. But please still feel free to ask questions in the chat or to use a dedicated Q&A function in Teams. Just like our first webinar, the presentations of our speakers will be recorded and made available later. So if you want to rewatch this webinar or watch our previous webinar, then you can do so through the Knowledge Center's YouTube page. To briefly reiterate the format, after a short introduction on the Knowledge Center and a state of affairs on the AI Act, 4 of my wonderful colleagues from CiTiP and myself will discuss 5 topics from the EU AI Act. We'll then also dedicate some time to your questions at the end of the webinar, but as mentioned, please feel free to already fire those questions in the chat as they come up during presentations. Now, what is the Knowledge Center Data and Society? We're a central hub in Flanders working around the legal, social, and ethical aspects of data-driven and AI applications. We have several objectives, including, as we are doing today, disseminating information disseminating information and knowledge to various stakeholders in the AI ecosystem, as well as contributing to the development of legal frameworks and guidelines. Similarly, in that vein, we also do this through reports, such as our recent report about policy prototyping and the policy prototyping exercise for the AI Act's transparency requirements that we held. In this exercise, we drafted 5 prototype documents, instructions of use, as well as disclaimers for AI systems under transparency requirements in the AI Act, together with various stakeholders for various use cases, in an attempt to meet the AI Act's transparency requirements. The insights and documents from that exercise, as well as our feedback on the AI Act's proposals, you can read in our report available on our website. Finally, the Knowledge Center is a collaboration between 3 Flemish universities, KU Leuven represented by CiTiP, VUB represented by SMIT, and UGent represented by MICT. Now, before we dive into our various topics, let's have a brief look at the current state of affairs of the EU AI Act. Let's all think back to April 2021, where you will remember that the Commission published its first proposal of the Act, followed throughout June 2023 by the Council and the Parliament's version and their respective texts. These 3 institutions then had trilogues last December and reached a political agreement, and COGEPER approved this agreement as well as the text in February 2024. Yesterday, as you will all undoubtedly know, the EU Parliament then voted on the AI Act and approved it, meaning that after still some textual corrections, the AI Act will be published and 20 days later enter into force. The rules in the AI Act will apply from 24 months in general after the entry into force of the AI Act, although there are some exceptions here. For example, prohibited AI practices. Those rules will already apply from 6 months after the entry into force. After 12 months, we'll see the application of the rules on GPI, so general purpose AI systems, as well as several rules on notifying authorities and notified bodies under the AI Act, as well as the rules on penalties. And notably, the obligations related to high-risk AI systems related to specific union legislation, so the high-risk systems that are under Annex 2, or rather that were under Annex 2 of the AI Act, but are now, since the Parliament's text, under Annex 1, those particular obligations will apply from 36 months after the entry into force of the AI Act. Now, all that remains for me is to give you an overview of the different topics that we'll handle in this webinar. First, Bilgesu Sumer will give us an overview of prohibited AI systems and practices in the AI Act. She'll then pass the virtual microphone to Victoria Hendricks for an overview of the high-risk AI systems. Lydia Balkadi will then discuss the roles of conformity assessments in the AI Act, followed by Andrea Palumbo, who will explain fundamental rights impact assessments to you. Then, at the end, I will close out our presentations with an overview of measures for SMEs in the AI Act before we move on to our Q&A section. Now, as mentioned, please do feel free to already post any questions that you have during the presentation in the chat. Then all I still have to do after this extended introduction is to give the floor to Bilgesu, who will introduce us to the prohibited AI systems and practices in the AI Act. So please take us away, Bilgesu.
Hi, everyone. My name is Bilgesu Sumer. I'm a doctoral researcher at CiTiP, and I'm going to talk about today prohibited AI systems under the AI Act. So as you might know already, the AI Act takes a risk-based approach, and this approach is supposed to tailor the rules to the intensity and scope of the risks that AI can generate. So according to the AI Act, it is necessary to prohibit certain unacceptable AI practices. So I will only cover the top of the pyramids, which are unacceptable practices, and my colleagues will touch upon the others. So to find the prohibited practices, we need to look at Article 5 of the AI Act primarily, and relevant recitals and Annex 2A. So to make it more clear for the audience, we can group prohibited practices into 4 broad categories. The first one is the AI systems that are manipulating or exploiting people. And the second one is social scoring. And third one is criminal risk prediction, also known as predictive policing. And the broadest category is the biometrics. So these are not absolutely prohibited, to mention at the outset. There are many exemptions, and we will be actually talking about the scope of those exemptions more than the prohibitions themselves. So let's dive in. So the first category is the AI systems that are subliminally manipulating people to deceive them to engage in unwanted behaviors. For example, deceiving them by nudging them into decisions in a way that subverts their free will. So the second one is the exploitation of vulnerabilities based on age, disability, economic or social status. Recitals are also giving examples to these economic or social status, such as extreme poverty, ethnic or religious minorities. Interestingly enough, not all types of manipulation or exploitation are covered here. For these practices to be prohibited, they need to cause or reasonably likely to cause significant harm. And significant harm is explained in recital 16 as sufficiently important adverse impact on physical, psychological health, or financial interests. For example, these might be caused by brain-machine interfaces or virtual reality. What is important here also is that the intention is not a necessary prerequisite, meaning that even if the intention of the provider or deployer of the AI system is not to cause significant harm, they would still be held accountable. There are also common exceptions, which are medical and psychological treatments and common and legitimate commercial practices, for example, advertising. So the second one is social scoring, leading to detrimental or unfavorable treatments. These, as you know, are prominent in some countries, and these are prohibited because they violate the right to dignity and non-discrimination, equality, and justice. And 2 types are specifically prohibited. The first one is the AI systems that social score people in social contexts over a long period of time, in social contexts that are unrelated to the context where the data was originally processed. For example, the data can be gathered from different contexts, to make predictions about a person, and then these predictions can be used and accumulated and used in other social context. These are prohibited. And the second one is if the social scoring is unjustified or disproportionate to the social behavior or its gravity, for example, excluding a person from enjoying certain activities is prohibited. And there is a common exception to these two provisions, which are lawful evaluations done for a specific person. And the third one is the criminal risk assessment or predictive policing. And in line with the presumption of innocence, people should not be judged on AI predicted behavior based solely on their profiling traits, personality traits, or characteristics. In fact, biometric plays already a big role here, but some examples are also given in the recitals, as nationality, place of birth, place of residence, number of children, debt status, or even type of their car. However, risk analytics that are not based on profiling. For example, the AI systems using risk analytics to assess the risk of financial fraud based on suspicious transactions, or risk analytic tools to predict the likelihood or localization of narcotics by custom authorities will remain allowed. And this brings us to the last category, which is the broadest one, biometrics. So biometric categorization systems are prohibited, but biometric categorization systems to infer sensitive categories of data, such as political opinions, religion, philosophical beliefs, race, sexual orientation, and so on, as described in Article 9.1 of the GDPR, are prohibited. But this does not cover the lawful labeling or filtering biometric data sets, such as the sorting of images based on hair color or eye color in the context of law enforcement. And the second category is real-time remote biometric identification in publicly accessible spaces for the purpose of law enforcement, which is found particularly intrusive to the rights and freedoms of persons. However, here we have again a set of exemptions. For example, strict necessity to achieve substantial interest, the importance of which prevails over the risks. Among those, we can list a search for certain victims, such as missing people or a threat of a terrorist attack. Also, there is a list of crimes provided in Annex 2A. And if those are punishable in the member states, it is possible to use real-time biometric identification to localize or identify the suspects. Also, identity checks at the borders are preserved for law enforcement and for the immigration and asylum authorities. And there are some conditions to real-time biometric identification to be used by the law enforcement, such as fundamental rights impact assessment, which will be explained by my colleague Andrea. And these need to be registered in overarching databases. So what is important here is also one point is very important, that for other purposes other than law enforcement purposes, the AI Act doesn't apply. And for those, we need to go to the sectoral or les speciales, or such as the GDPR and the other regulation. So emotional recognition is also prohibited, but only in a workplace and education. These are defined as identifying or inferring emotions or intentions, and they include happiness, sadness, embarrassment, and so on, but it does not include physical states such as pain or fatigue. So the provision are written considering the imbalance of power in the context of work or education, thus they are prohibited. And the last one is the creating or expanding facial recognition databases through the untargeted scraping from the internet or CCTV footage, which was also popularized by Clearview AI. And the reasoning is that such practices adds to the feeling of mass surveillance and that they violate the right to privacy, obviously, and which leads to chilling effects. There are no explicit exceptions for this category. So hereby I finish my presentation. I would like to give the floor to my colleague Victoria Henriks, who will explain high-risk AI systems. Thank you.
Thank you. Hello, my name is Victoria, and in this part, we are going to explore high-risk AI systems under the AI Act. The focus of this part really lies on the classification, so the question when an AI system is considered high risk under the AI Act. From the outset, it should be mentioned that high-risk AI systems are not per se prohibited, but rather permitted but subject to compliance with AI requirements and ex-ante conformity assessments, and this is because they are considered to have a potential to adversely impact people's health, safety, or fundamental rights. So let's take a look at Article 6, which distinguishes between two categories of high-risk AI systems. The first paragraph refers to AI systems that are used as a safety component of a product or falling under European harmonization legislation. And the second paragraph refers to a list of standalone high-risk AI systems. So let's dive into the first paragraph, which states that AI systems shall be considered high risk if, first of all, the system is intended to be used as a safety component of a product, or is itself a product covered by Union harmonization legislation listed in Annex 2, and the product is required to undergo a third-party conformity assessment. Examples of such AI systems that are used in products falling under Union harmonization legislation range from machinery to toys, aviation, cars, medical devices, lifts, and so on. But be aware that while they are considered high risk, not all requirements under the AI Act are applicable to the second section of Annex 2, which might be Annex 1 in the newest version. So now let's go to the second paragraph, the standalone AI high-risk systems. But before discussing them in more depth, it's important to mention that there's a derogation foreseen at the request of the Parliament. It's a so-called filter provision, and according to this provision, AI system is not considered high risk if it poses a significant risk of harm to the health, safety, or fundamental rights of a natural person. Providers themselves have to assess this, but they're guided through the criteria that are foreseen in the text, such as, for example, is the AI system intended to perform a narrow procedural task? And an example is given in a recital, such as, for example, transforming unstructured data into structured data. Another important point is to mention that providers who make use of this derogation must register that decision in the European database. However, an AI system is always considered a high-risk AI system that performs profiling of natural persons. But suppose we do not fall under such derogation, then we can look at the 8 areas which Annex 3 identifies. Do you know we could actually talk about every area a lot longer, so we're going to have a quite dense presentation now. So the first area is the one of biometrics, and as already explained in the first part, they are not always allowed, but insofar as they are not prohibited, they could be seen as high risk. And 3 subcategories are identified. First of all, remote biometric identification systems are considered high risk, but what is not included under that are AI systems that are intended to be used for biometric verification with a sole purpose to confirm that a specific person is who he or she claims to be, for the sole purpose of having access to a service, unlocking a device, or having security access to premises. In point B, systems that are intended to be used for biometric categorizations are also identified as high risk. What is not included are systems that are purely auxiliary features linked to another commercial service. Luckily, the recitals also give an example of that. And I mentioned, for example, filters that are used on online social network services, which categorize facial or body features to allow users to add or modify pictures or videos. Because these filters cannot be used without the principal service of the social network service, consisting in sharing content online. And lastly, we have systems intended to be used for emotion recognition that are considered high risk. So when they're not used in a workspace or in education, they could be seen as high risk. And what in general is applicable is that biometric systems which are intended to be used solely for the purpose of enabling cybersecurity and personal data protection measures, they should not be seen as high risk. Let's turn to the second area, which is much more straightforward, and that's saying that systems intended to be used as a safety component in a management operation of critical digital infrastructures are considered high risk. And examples are systems for monitoring water pressure. The third area is about education and vocational training. 4 systems are identified as high risk under this area, namely systems that are intended to be used to determine access or admission or to assign persons to a training. And an example that comes to mind is the UK exam algorithm that was used a couple of years ago that assigned a grade to a student that would later determine to which university that person have access. And under now the regulation, it would be considered a high risk AI system. The other systems are systems intended to be used to evaluate learning outcomes, systems to assess appropriate levels of educations, or systems intended to be used for monitoring and detecting prohibited behavior of students during tests. The fourth area is the one of employment, workers' management, and access to self-employment. Here, it's first of all identified that systems intended to be used for recruitment or selections are considered high risk. We could think of the Amazon recruitment algorithm that was used a few years ago that discriminated a lot against a woman. That would now be considered high risk. And the second systems are systems intended to be used to make decisions affecting terms of work-related relationships, about promotion and termination, about allocation of tasks, or to monitor and evaluate performance and behavior of persons. Turning to the fifth area, that's the one of access to and enjoyment of essential private services and essential public services and benefits. Here there are again 4 subcategories. First of all, identified as high risk are systems intended to be used by public authorities to evaluate the eligibility of persons to get essential public assistance benefits and services. Once again, an example is the Dutch childcare benefits scandal, in which the Dutch government used an algorithm that decided whether or not a person would get a child care benefit, but was highly biased. A second high-risk systems are the ones that are used to evaluate the credit worthiness, with an exception of AI systems used for the purpose of detecting financial fraud. The third one are systems intended to evaluate and classify emergency calls, and the fourth are systems used for risk assessment and pricing in relation to natural processes in the case of life and health insurance. The sixth area is the one of law enforcement. And again, insofar as they are not prohibited, they should be considered high risk when they intend to assess the risk of a natural person to become a victim of a criminal offense, when they help to evaluate whether somebody it says the risk of somebody offending or reoffending, when they're used as a polygraph or as a similar tool, when they are used to evaluate the reliability of evidence, or when they're used for profiling in the course of detection, investigation, or prosecution of criminal offenses. But what is not covered by the high risk category is AI systems that are used for administrative procedure by tax and custom authorities, as well as financial intelligence units carrying out administrative tasks analyzing information on union anti-money laundering legislation. Turning to the seventh area, it's the one of migration, asylum, and border control management. Insofar as they are not prohibited, they are considered high risk when they are used as a polygraph, when they are used to assess a risk, when they are used to examine an application for asylum, visa, or resident permit, or when they are used for the purpose of detection, recognizing, or identifying a natural person. Then we turn to the last area, and that's the area of administration of justice and democratic processes. First of all, systems intended to be used by the judicial authority to assist them in researching and interpreting facts in the law, as well as applying the law to a concrete set of facts, and similarly in alternative dispute resolution are considered high risk. But what's not included are just purely ancillary administrative activities. And secondly, AI systems intended to be used for influencing the outcome of an election or referendum or the voting behavior are also considered high risk, but what's not included are AI systems purely for administrative and logistic points for example, organizing, optimizing, and structuring political campaigns. So as a conclusion, a few remarks. Article 7 provides that the Commission is actually empowered to adopt delegated acts to modify Annex 3 of the high-risk AI standalone cases by adding or modifying them under certain conditions. And once a system is identified as a high risk, a whole range of obligations are applicable to them, and they can be found under Chapter 2. They range from risk management to keeping technical documentation, to foresee in human oversight, but also to carry out conformity assessments or fundamental rights impact assessments, of which my two colleagues will talk. And on that note, I'm happy to give the floor to Lydia, who is going to talk about conformity assessments. Thank you.
Thank you very much. So my name is Lydia Belkadi. I'm also a doctoral researcher. My research focuses on the legal aspects of biometric recognition and related AI technologies. So today, with this presentation, I will attempt to provide you with a very short introduction to conformity assessments under the AI Act, with the knowledge that there is actually a lot to unpack. This is a keystone provision in the text. So we will only focus now on 4 main questions. What are the main aims of conformity assessments? Who should carry them out? What are the different procedures, and which procedure applies to which high-risk AI system? So conformity assessment is defined as a compliance process with the goal for an organization to be to demonstrate compliance of their high-risk AI systems with the 7 key requirements set out in Chapter 2. There are rules that must be followed for the development, the design, and the use of high-risk AI systems, for mitigating the risk they pose to health and safety and to fundamental rights. And thus, these requirements will address the setting up of a risk management system aiming to identify, evaluate, and mitigate the risks posed by AI, data governance, particularly during testing, the drawing up of technical documentation, which is very important for documenting compliance with the requirements as well, as will be seen later on. Record keeping, transparency and provision of information, human oversight, accuracy, robustness, and cybersecurity. Compliance with these requirements will be key for entering the single market or putting high-risk AI systems into service. So as explained in the recital, the aim is to contribute to ensure a high level of trustworthiness, which, as some of you may know, is the trustworthy AI is the main ethical framework created for developing these requirements. So now, who should carry out the assessments? Well, in answering this question, we need first to clarify, on the one hand, who has the legal obligation to perform it, in other words, who is responsible for conformity assessments, and on the other hand, who will effectively carry out the procedure. This clarification is important because the provider is always the one who must make sure that his or her AI system, when classified as high risk, undergoes a conformity assessment. It is also the provider who is responsible for demonstrating compliance with the requirements upon authorities' request. The concept of provider will be defined in Article 3. It will refer to a natural or a legal person, a public authority, an agency, or other bodies. So the qualification of provider is quite broad overall, and what counts is that this organization either develops a high-risk AI system, has a high-risk AI system, and places it on the market, or puts a high-risk AI system into service under its own name or trademark. I insist on the qualification of high risk because conformity assessments only apply to those systems, and different type of obligations for providers of general purpose models and systems apply, which was also the topic of a presentation during our previous webinar. So now more concretely, who will actually perform the assessment? Well, there are two different procedures established in the annexes of the AI Act. First, we have the conformity assessment procedure based on internal control. And the second, the conformity assessment based on both an assessment of the quality management system and the technical documentation. The procedure based on internal control will be carried out by the provider himself, while the other one will be carried out by a third party designated as under the AI Act as a conformity assessment body, which additionally fulfills requirement to be qualified as a notified body. So these terms are defined. More obligations will apply to notified body regarding their denominations, responsibilities, and so on, but we don't really have time to delve into that now. What is important to note is that notified body will be established at national level, so it is within your own national authorities that you have to look for it. Now, what are the different procedures that may apply? So before actually delving into these two possible procedures, it's necessary to qualify a couple of compliance tools very briefly. So namely the quality management system, technical documentation, and post-market monitoring system. Why it's important to also broaden the analysis to these three obligations and provisions is that they are the primary material that will be examined during conformity assessment procedure. So first, the quality management system must be composed of written policies, procedures, and instructions, aiming to systematically document the design, development, and testing of high-risk AI system. It must address several regulated aspects, for example, including strategy for regulatory compliance, including compliance with the obligation of carrying out a conformity assessment procedure, procedures for managing modifications to the high-risk AI system, other documenting the techniques or procedures regarding controls and verifications of the system, quality testing, data management, and so on. This article is quite lengthy, so I would recommend to directly read it. The quality management system also bridges with other compliance systems, such as the risk management or post-market monitoring systems. So this article is genuinely the main keystone for regulatory compliance strategy. The second pillar is technical documentation, which must be drawn up before the placing on the market or putting into service of an AI system and kept up to date. While the quality management system and post-market monitoring system can be established for several AI systems, each high-risk AI system must have its own technical documentation. So there's actually a need to draw up several documents under a single compliance framework. The provider must document the way high-risk AI requirements have been taken into account and so on. Further details are contained in Annex 4. And finally, the post-market monitoring system is meant to actively and systematically collect, document, and analyze data on the performance of high-risk AI systems throughout their lifetime for ensuring continuous compliance. So now, in a nutshell, the conformity assessment procedure will consist in verifications of quality management system, technical documentation, post-market monitoring. Where it's possible to opt for the procedure based on internal control, the provider carries out the relevant verifications and assessments, verifying the completeness and quality and adequacy of the quality management system, the content and quality of technical documentation, and the consistency between what is written in the technical documentation and the actual design and development process and post-market monitoring system. In the case of the procedure based on third-party conformity assessment, the procedure is a bit more complex. It must always be initiated by the provider, who must file two distinct applications. So one application relates to the quality management system, and the other to the technical documentation. And the review will similarly consist in verifying compliance with the articles, but the notifying body will be additionally responsible for monitoring and post-market surveillance. For example, it will need to be informed of any intended change to the quality management system or to the list of AI systems covered, and so on. In the context of reviewing of the technical documentation, the notified body may gain full access to the training, validation, and testing datasets, for example, through means for remote control, and where it can also ask for additional testing or evidence, and can, in certain cases, conduct these tests itself. And so if the systems if the quality management system is compliant, if the technical documentations are also compliant, this leads to, this opens the possibility for the provider to draw up its EU declaration of conformity, which is mandatory. And also to affix the CE marking. I'm a little bit over time, so I will try to be more to wrap up now. I'm sorry. So which procedure applies to which type of high-risk AI system? Well, other than for 7 out of 8 high-risk AI system categories, the answer is, the lawyer's answer, it depends. Because it depends on the availability of technical standards or technical specifications. It depends on the actual implementation by the provider. For the last category, so listed in Annex 2, it depends on what the harmonized legislation says, and the AI Act provides guidance on how to bridge certain texts. And in all other cases, well, for now, the AI Act provides assessment based on internal control. Some key takeaways. So as I hope was clear, the quality management system and technical documentations are really key for demonstrating compliance. While also conformity assessment must be examined on a case-by-case basis. Additional aspects have not been discussed here, such as presumptions of conformity, derogations in exceptional cases, substantial modifications, and so on. A note something worth noting is that the procedures could evolve in the future under the initiative of the Commission, who can adopt delegated act, particularly where now the procedure is based on internal control. Thank you, and apologies for the overtime. And now, hand the floor to my colleague Andrea.
Thank you, Lydia. My name is Andrea Palumbo. I'm a researcher at CiTiP, and I will be presenting on the fundamental rights impact assessment. This is a new there's a new obligation in the final text of the Act for deployers to carry out a fundamental rights impact assessment in relation to the risks that the AI systems that they deploy could pose for the fundamental rights of affected individuals and groups of persons. The relevant obligation to carry out the fundamental rights impact assessment that I will call FRIA, using its abbreviation, is in Article 29A of the final text. And there is also only one recital, which is recital 58G, that provides some clarifications on the rationale and application of this obligation. And I just wanted to first briefly mention that there has been a bumpy road leading to the adoption of this article, and it has been the object of heightened debates between the European Parliament and the Council during the legislative procedure. And the final text of the article reflects the compromise that was reached between the European Parliament and the Council when they reached the political agreement. Now, moving on to my presentation, I will be talking about the material and personal scope of application of this obligation, so who it applies to, what AI systems are covered, and when the FRIA should be carried out. I will then describe the steps to be taken to perform the FRIA. I will then provide some insights into how the FRIA should be carried out and which fundamental rights are in scope. And then I will conclude by briefly describing the interplay between the FRIA obligation and other obligations in the AI Act and in other legislative acts of European Union law. So first, starting with the material scope of application, the FRIA must be carried out in relation to all high-risk AI systems, with only one exception, which concerns the AI systems to be used as safety components in critical infrastructure. This is one of the areas of AI systems that my colleague Victoria described before. But besides this exception, all high-risk AI systems are in scope. And when does the FRIA must be carried out? Deployers must carry out the FRIA before the system is deployed into first use. So the results of the FRIA must already be available before deployment into first use. Nonetheless, even after deployment into first use, the deployer is obliged to update the information of the FRIA if needed, conducting an additional assessment if it considers during the use of the risk system that the information in the FRIA needs to be updated and it's no longer relevant. And this entails that there is a monitoring obligation on the part of the deployer to continuously assess the relevance of the FRIA. With regard to the personal scope of application of the FRIA, this obligation is imposed on deployers only, so it does not apply to providers. And it is imposed only on 3 specific categories of deployers. This is one of the aspects on which a compromise was reached between the European Parliament and the Council, because the Council wanted to limit the scope of application of this obligation only to these deployers. I'm providing here a list of deployers in scope as indicated in Article 29A. We have bodies that are governed by public law. We have private operators providing public services, and here, in relation to this category, there are some open interpretative questions to be answered, because public service is not defined in the AI Act, but there is some guidance in recital 58G on which tasks could be considered as the provision of a public service by a private operator. And finally, we have operators that deploy high-risk AI systems in 2 specific use cases. And these 2 use cases relate to the use of the AI system to take decisions that can have a significant impact on the lives of consumers in the banking and insurance sectors. In particular, the first use case relates to the evaluation of the creditworthiness of natural persons or the establishment of fair credit score. And the second use case relates to the risk assessment and pricing in relation to natural persons in the case of life and health insurance. And so as the rationale behind this category is that indeed the EU legislator wanted to protect potentially vulnerable consumers where these types of decisions are taken using high-risk AI systems. I will now then describe the steps to be taken. So the FRIA basically requires the performance of an impact assessment of the impact of high-risk AI systems on fundamental rights. And there are 6 elements that must be assessed as part of the FRIA and must be described in the final document resulting from the assessment. These elements relate to the processes where the system will be used, the period of time and frequency of the use, the persons and groups that might be affected and how they will be harmed, the human oversight measures implemented during the use of the high-risk AI system, and which measures will be implemented by the deployer to mitigate the specific risks posed by the high-risk AI systems as identified during the performance of the FRIA. And one point I really wanted to stress is that the deployer can, in performing the FRIA, take into account the impact assessments previously performed by other entities, and most importantly, by the providers of the AI systems. As my colleague Lydia already explained, there are certain risk management obligations imposed on providers of AI systems, and these risk management obligations can lead to assessment that can also become relevant when performing the FRIA. Once the FRIA has been performed, the results of the FRIA must be notified to the Market Surveillance Authority, and in doing this, deployers must use a template that will be developed by the AI office. I wanted to underline that this obligation is an obligation of conduct to assess the impact of the AI system on fundamental rights. Therefore, Article 29A does not lead to a full horizontal application of fundamental rights in the relationship between deployers and affected persons or groups of persons. So it is more of an obligation to perform certain actions, and insofar as certain actions are carried out, then the obligation is complied with. And an important question to answer is which fundamental rights are in scope, which fundamental rights must be taken into account when performing the FRIA. Unfortunately, there is no clear indication in the AI Act in Article 29A or in the recitals, but based on a number of elements, it can be affirmed that at least the fundamental rights recognized in the EU legal order should be taken into account, such as the rights recognized by the Charter of the European Union, any fundamental rights recognized in the treaties, or as general principles of EU law. And then it's important to mind the connection between the Charter and the European Convention on Human Rights, which establishes a minimum standard of protection of fundamental rights that must be respected also in the EU legal order under the Charter. It is not clear to what extent national fundamental rights should also be taken into account, and on this point, hopefully, guidance will be provided in the future. I wanted to provide a few insights on what we know so far about how the FRIA should be carried out, besides the steps that I described before, how it can be carried out in practice. The primary guidance will probably come from a template for a questionnaire that will be developed by the AI office and will have to be used also for the notification. And then Recital 58G indicates some of the activities that can be carried out, such as putting in place complaint handling and redress systems, or involving stakeholders in consultations while performing the FRIA. It is also important to mention that insofar as a certain activity for the same activity, for the same use of the high-risk AI system, a data protection impact assessment must be carried out, and also the FRIA. So there is an overlap between the scope of application of the data protection impact assessment and the FRIA. The two assessments must be conducted in conjunction, and this is an obligation that stems directly from paragraph 4 of Article 29A. Even though the data protection impact assessment is limited to the assessment of the impact on the right to data protection, then, however, they can be carried out in conjunction, and then the FRIA would just have a broader scope. And then I wanted to also talk about the possibility to rely on other templates and models already developed for the assessment of the impact of technologies and private activities on fundamental rights. Because before the AI Act, there were already instruments in place regarding the impact assessment of private activities on fundamental rights. I will just mention a few. There are the United Nations Guiding Principles on Business and Human Rights that require a human rights due diligence. There is a risk assessment mitigation framework in place in the Digital Services Act that is also relevant for fundamental rights. And then most importantly, there are a number of public and private initiatives about fundamental rights impact assessments. In particular, I will mention the Fundamental Rights Algorithmic Impact Assessment developed by the Dutch government and the Fundamental Rights Impact Assessment developed in the context of the Liner project. And finally, I just wanted to say a few words regarding the interplay between the FRAIA and other obligations in the AI Act and in other legislative instruments. Regarding the AI Act, providers have to put in place a risk management system under Articles 9 and 52 D1B. And as part of this, of their obligations under these articles, they must assess and mitigate the risks that the AI systems that they provide pose, among others, to fundamental rights. And therefore, there is already an assessment that is being conducted in relation to the AI systems. As I said before, the assessments conducted in this context might, they don't necessarily do, but they might also be relevant for the performance of the FRAIA, and they can be relied on while performing the FRAIA. And of course, also harmonized standards will be developed to specify how these risk management systems should be put in place, and also even there might be useful guidance for the performance of the FRAIA, even if harmonized standards are not related to the FRAIA per se. But of course, there is the interplay between, on the one hand, the provisions on the data protection impact assessment of the GDPR and the Law Enforcement Directive, and on the other hand, Article 29A on the FRAIA. And finally, there is an upcoming directive on corporate sustainability and due diligence that will require certain large companies to assess and mitigate the potential adverse impacts on human rights of the environment of the activities performed by these large companies. And here there might be an overlap between the obligations already imposed on certain large companies by this directive and the obligation to conduct a FRAIA. And it will be interesting to see how this interplay will play out in the future once the directive has been adopted and will start apply in the member states of the European Union. So this was my very quick overview of the FRAIA obligation, and this is the end of my presentation, and I will leave the floor to Vance for the next presentation. Thank you.
All right, thank you, Andrea, both for giving me the floor and for your very clear presentation on the FRAIA. I will then introduce us to some measures for SMEs that are currently included in the AI Act. The goal of these measures by the different EU institutions is, of course, to remove or lessen obstacles, make obstacles currently in the new obligations of the AI Act more manageable for SMEs who want to place their AI system on the market or who want to put an AI system into service. After all, we don't want these companies to be blocked from the market by regulatory burdens. Now, when we examine the AI Act for these measures, we'll find that many of these measures still require further implementation or further development by various entities, such as the member states and competent national authorities, but also by the AI Office and the Commission. Still, we'll also be able to find some specific, already more tangible measures that can currently be identified in the Act. So let's get into this. Starting at a member state level, we see that in the AI Act, member states have to organize specific awareness raising and training activities on the application of the Act, tailored specifically to the needs of SMEs. Member states will also have to use their dedicated channels or establish new dedicated channels where appropriate to communicate with SMEs and provide them with advice or respond to their queries about the AI Act. They also have to facilitate participation of SMEs and other stakeholders in the standardization process. And when member states support the drafting of codes of conduct, they have to take SME interests and needs into account. These codes of conduct, just for context, for example, could include voluntary codes of conduct to voluntarily apply certain AI requirements to, let's say, non-high-risk AI systems. Finally, member states have to take into account SME interests and specifically as stated in the text, like economic viability when determining the rules on penalties and other enforcement measures for infringements of the regulation. So as you might be able to tell from this overview of the measures for member states, the wording of these measures is still quite general, and they give a broad possibility for member states to still calling in these various obligations. So we'll have to see in the coming years, in the coming months, hopefully, actually, how these different member states will handle these different measures and support their SMEs in handling the regulation. Now, we also see on a national level, on the level of national competent authorities, notified bodies, other considerations for SMEs. Some of these are already more specific. Not the first point on this slide, though. National competent authorities can, of course, give guidance and advice in general on the implementation of the regulation. They have to take into account the Commission's guidance and the Commission's advice in this. They do this towards all involved parties, these national competent authorities, but they also do this in particular also to SMEs. More specifically, and already a bit more tangible, is that the fees for conformity assessments asked by notified bodies for SMEs shall be tailored to those SMEs, meaning that they reduce proportionally to the size, market size, and other indicators of the SME. So here we already see perhaps a bit more tangible results from these measures. Finally, it should be noted that competent authorities, when they impose a fine for non-compliance with the AI Act, normally do so up to a higher limit of either an absolute amount of money or a percentage of a company's annual turnover. For SMEs, however, the limit of this fine will be the lower of those two numbers. So to illustrate with an example, non-compliance with the prohibition of certain AI practices in the AI Act, the topics that Birgesu covered, those are normally fined up to a limit of 35 million euros or 7% of annual turnover. For regular companies, whichever of these limits is higher, but for SMEs, it'll be whichever of those limits is lower. So in most cases, likely this 7% turnover as a limit instead of this 35 million euros. Now, aside from actors on a national level, we also see that several entities at the EU level still have to implement measures to support SMEs. The AI Office, established in the European Commission, can provide, for example, standardized templates for areas of the regulation for SMEs, for example, to do with the fulfillment of certain obligations in the AI Act, helping them complete these obligations to the templates. And the office must also develop and maintain a single information platform with easy-to-use information for all operators of AI systems in the Union. The office also has to set up a communication campaign to inform different companies about the obligations in the AI Act, and they can evaluate and promote best practices for public procurement procedures related to AI systems, also where SMEs are involved. We then also see, of course, that like member states, where they facilitate in drafting codes of conduct, that the AI office and the Commission will have to take into account SME interests, and the Commission specifically, where it develops guidelines on the implementation of the regulation. That's this last point. They have to do so, paying particular attention to the needs of SMEs that are affected by the regulation. So again, for the AI Office and the Commission, we see more general, broader obligations that still have to be filled in the coming months, in the coming years. Although we do also see a bit more tangible results here with these standardized templates for the regulation that the AI Office can make on request of the AI Board, and with this single information platform that will be created. Now, on the topic of more tangible measures, we already have currently in the obligations of the AI Act two parts where SMEs and in some cases micro enterprises specifically are subject to more simplified obligations. This is the case for technical documentation related to the high-risk AI system. So as Lydia has also briefly mentioned, the documentation that has to demonstrate the system's compliance with the requirements for high-risk AI systems, and it has to contain all the elements set out in Annex 4 of the regulation. There, SMEs will be allowed to provide several of these elements in a simplified manner. The Commission will draft a documentation form for this, taking into account specifically the needs of small and micro enterprises, although all SMEs will be able to use it, and notified bodies will have to accept this form during the conformity assessment procedure. In particular, for micro enterprises specifically, we also see that they will be able to fulfill certain elements of their obligations towards a quality management system. So as already mentioned, this quite long list of requirements, including strategies for regulatory compliance, design, verification of the AI system, and so on. There, the Commission will develop guidelines on how exactly micro enterprises may fulfill certain of these requirements in a simplified way. So already more concrete support for SMEs, because we're not only in this case, or rather the Commission is not only in this case supporting them in achieving the requirements, but also to some degree simplifying how the requirements are fulfilled. Finally, there are some measures for SMEs in the rules on regulatory sandboxes. Regulatory sandboxes, in case you weren't present for our last webinar, or would like a reminder, are frameworks created by authorities to give providers the possibility to develop their system under regulatory supervision. One of our colleagues, Katrina Jordanova, in our previous webinar went into good detail on this and gave a great talk on it. So if you haven't checked it out, I would recommend you do so. For this webinar, though, you need to know that one of the explicit objectives of these regulatory sandboxes is to facilitate and accelerate access to the market for AI systems created by SMEs. That's done through several provisions, many of which will still need to be included in the implementing act for these regulatory sandboxes that will be drafted by the Commission. But what the AI Act already determines is that in this implementing act, there must be rules or other provisions that enable SMEs to have free access to these regulatory sandboxes, with the exclusion of some exceptional costs, and that the sandbox procedures and processes have to be accessible to the SMEs, meaning that they have to be simple, intelligible, clearly communicated so that they are not a barrier of entry for SMEs. Finally, prospective providers in sandboxes will also be directed to pre-deployment services, meaning to specific guidance on the regulation, and to other value-adding services, such as, for example, help with standardization. On a member state level, then finally, we see that member states will have to provide SMEs with a registered office or branch in the Union with priority access to their AI regulatory sandboxes, if, of course, these SMEs in the EU fulfill the eligibility conditions and criteria. Now, this priority access, of course, doesn't exclude other SMEs from participating, provided they also meet the conditions and the criteria. And that brings me to the end of my presentation on the measures for SMEs in the AI Act. I think, as you can clearly see, there are quite a few measures included to support SMEs, but they also still require a lot of implementation and a lot of execution by various actors. And this will be very determining in how easily SMEs can adapt to the obligations in the AI Act. Which then, of course, brings us to the last part of this webinar, our Q&A. I've already seen many questions come in to the chat. I'm afraid we won't be able to, within the constraints of our time, handle all of them, but we have some that we can definitely ask to our various presenters. And I think we'll just go in the order in which we gave presentations, starting with Bilgesu. If you don't recognize your question immediately, I have briefly adapted them just to be easier to parse in our limited time. But Bilgesu, coming back to prohibited AI practices, to real-time biometric identification in public places by law enforcement, there was a question and some questions related to the limits of this biometric identification in public for law enforcement. Could you tell us maybe a bit more about the legal basis that such an identification has to follow, the permissions that it has to acquire from courts and authorities?
The question is how will we be able to limit the real-time biometric identification in public places only for the use for missing people or terrorism? This is not the only limitation, first of all. So there are also criminal offenses listed in Annex 2. And if these are already provided by the member state in their national legislations as the crimes that are, if I'm correct, that requires more than punishment for like 4 years, then these are also allowed. But I agree with you, of course, only as the purpose definition is not going to be de facto to limit the real-time biometric identification in public places. So there is no, of course, like real genuine answer to that I can give, but I take this question also as a little bit of criticism. So yeah, if that is a rhetorical question, that I agree with the who asked the question, Amidi. And I see another question also that is about emotional recognition systems in workplace applied to emails. Documents or other not necessarily biometric data can be considered prohibited, or the link with biometric data is necessary. This should be covered by the GDPR, as actually in the previous versions of the AI Act, before it was agreed on, there was a concept called biometric-based data. So from that, we understand that these emotional recognition systems should be based on biometric data, and this concept of biometric-based data further eliminated in the latest versions. So we should, I think, consider this as these emails and documents and emotional recognition from other type of data than biometric data should be covered by the GDPR. So I cannot see any other question that should be directed to me, but feel free to, of course, direct any questions that might.
All right, definitely. Thank you for your great answers. I'm sure people who still have questions about prohibited AI practices can reach you. Victoria, then, we still had some questions related to the link and possible crossover between prohibited and high-risk AI systems. For example, seems to be some overlap on broader categories like biometric identification, emotion recognition. Could you maybe there clarify where the dividing line is between what's a prohibited AI system or a high-risk AI system is?
That's indeed the $1 million question. It's sometimes blurry whether it's a prohibited AI systems or a high-risk AI systems. That's why there was also a question about why I sometimes mentioned insofar as prohibited, because that was when a high-risk AI system would have a link with a prohibited AI system. So in my perspective, I think if I read it correctly, prohibited AI systems are very narrowly defined. So if you would not fall under that, then you would come into the high-risk AI system layer. And as said, the layers are sometimes blurry between what's prohibited or what's not. For example, with emotion recognition, but there it's actually quite clear. It's prohibited in workspaces and in education. But for all other use cases outside of these two areas, it could be used, but then subject to all these ex-ante requirements and conformity assessments. So I cannot give a very clear defined answer to when it's a prohibited or when is it a high risk, because it all depends again in law. So my apologies for the unclear answer, but then I saw another question I think was directed to high risk AI systems, and that was something regarded like essential private services may be included funding for SMEs, public infrastructure shall be credit risk and due diligence performed by investment bank for awarding a loan. Should that be considered high risk AI system? I think that relates to a question about, like, I'm not sure, but I think for critical infrastructure, whether or not that should be seen as a component of that should be considered high risk. And in my opinion, if I read the AI Act, not, because a safety component is rather narrowly defined. So I would say it's not considered a high risk AI system. And I hope that's clear.
All right, I believe that it is, and that we can also address some questions then related to conformity assessment procedures. Lydia, I see you've already answered this question in the chat, but maybe for recording and for people who aren't actively reading at the moment, could you clarify who can become a notified body that will perform these conformity assessments? How will they be selected?
Yes, thank you for the question. So the procedure is defined in, if I'm not mistaken, 1 second, I need to double check because this was not on my slides. Yeah, it is defined in Article 31. So the procedure is open to conformity assessment bodies. So this is defined. It's a body that performs third-party conformity assessment activities. So probably already a body that is already active in this field of conformity assessments, but it will additionally need to be nominated. So this procedure will be carried out with national notifying authorities, where where the conformity assessment body will need to document or provide documentary evidence on it will need to document like the conformity assessment modules that they propose, the assessment activities, and so on. So so the procedure are now in the text, but how they will actually be rolled out is I'm not entirely sure now.
Okay, that indeed matches my understanding. Indeed, these notified bodies will go to these notifying authorities, present evidence, or rather, conformity assessment bodies will go to notifying authorities, present evidence that they can fulfill their tasks and be monitored then as notified bodies by these different notifying national authorities. All right, wonderful, thank you. Andrea, then we've had quite some questions related to this template FIA that will be developed by the AI office. Do you know already, are there indications whether this will be mandatory or not? What we can do in the meantime? Are there any practical pointers that you can give people around this template, how to prepare for it, and so on?
Thank you, Vance. Yes, I wanted to address indeed this question. In my understanding, this template is supposed to be a non-binding guidance provided by the AI office to facilitate compliance by deployers with the obligation to conduct a FRIA. It must also be taken into account that in the general supervisory and enforcement architecture, regulatory architecture as well of the AI Act, the Commission can adopt implementing acts, which are binding acts, legal acts under EU law that have indeed binding effect. I can also have, they can be structured in a form similar to that of regulations, for example. So this binding guidance should be provided by the Commission that is empowered directly by the AI Act to adopt this type of acts, whereas the AI office does not have this type of empowerment, in particular in Article 29A, paragraph 5, that talks about the template, and it's clear from the recital that should be non-binding guidance. Regarding the question about whether also other types of templates can be used or a different way of carrying out the FRIA can be followed, but it depends on how strongly recommended the template will be by the AI office. Of course, the objective that the AI office will pursue will be that of facilitating compliance, because this is actually a complex obligation and they want to reduce the burden for deployers. This was actually a very debated point during the legislative procedure, because the industry associations and the council, they stressed that the FRIA, as originally formulated by the European Parliament, would have been too burdensome for deployers. So this is also, the idea is to reduce the burden for deployers. So non-binding guidance is not excluded that other templates might be used, but probably it would be useful for deployers to follow this template, and it will facilitate to prove that indeed they're being compliant with the obligation. And regarding also very quickly the other templates developed, for example, in this context of the Aligner project or by the Dutch government, indeed this can just now be useful to have an idea of what might be what a fundamental rights impact assessment might be in practice. And of course, besides these two, there are also other templates. I mentioned these two for the sake of time. So this can be useful now to have an idea of what it means to do an impact assessment of how an AI risk AI system impacts fundamental rights. But of course, it's just to have an idea for now, and I believe it will be best to wait for the template by the office before having reaching conclusions on how the FRIA should be structured in practice.
All right, I think that's very clear. Thank you for that. A question I see returning for the measures on SMEs is, of course, where we'll find all this different guidance. And I'm afraid at the moment there aren't quite specifications on where, for example, the DI office will post these dedicated templates, or where you can find all of this information from national competent authorities. That's something that will remain to be seen. Of course, the DI office is established in the Commission, so I think it's definitely worth monitoring the Commission's activity on these points, as well as looking towards your regular national competent authorities, perhaps making a bit the how should I say, comparison with GDPR, where you also monitor both the DPB's guidance, as well as whatever your national competent authority decides and publishes in terms of guidelines. Now, I see we still have quite a few questions and discussions going on in the chat. I'm sure you'll be all quite happy to continue those perhaps after the webinar, but time-wise, we are unfortunately running out. And that, of course, requires me to end the webinar here and thank all of you for attending, as well as thank all of my wonderful CiTiP colleagues for their clear and thorough presentations. Should you still have questions or concerns about the AI Act, about the various topics, you can, of course, contact us through the email addresses that you've seen on our different sites, but also you'll find our contact details on CiTiP's website. If you want more information or rather more legal content, let's say, about these different topics, be sure to visit CiTiP's website and blog, as well as the website of the Knowledge Center Data and Society. And I hope you all still have a very wonderful afternoon.